Okay, everybody. Hello, how are you? We're here today to talk about estate planning for blended families. I am Britt Burner, one of the attorneys here at Burner Law Group, and I'm happy to discuss this topic with you. When we talk about blended families, we're talking about the second marriages, and very oftentimes, we're talking about the Brady Bunch. Maybe they had children from a prior marriage. They might even possibly have children from a prior marriage and also have children together. We also come across a lot of families who have one spouse that has children from a prior marriage, but the other does not. And when we're looking at estate planning for these individuals, we really need to know the dynamics of what's going on in the family and what the goals are in order to be properly supporting the goals of everybody in, or both members of the couple. And so that's what we're going to be talking about today. If we always like to talk about what happens if we do nothing. What happens if we get remarried and we don't want to deal with this and we just put our head in the sand and we say, I'm not doing a will, I'm not doing a trust, I'm not going to do any estate planning. What would happen? And that's what we call intestate. When somebody dies without a will, it is dying in intestacy. Now, if you have a home that's joint, or you own it joint with right of survivorship or tenancy by the entirety, that's going to go to the joint owner. If you have a bank account that's joint, again, that's going to go to the joint owner. So that may go to the spouse. If you have a retirement account that perhaps has a beneficiary named on it, that's going to go to the beneficiary. So what we're really talking about here are what happens to the things that are in your sole name with no beneficiary upon your death when you have this situation. So I'm going to give an example. Let's say somebody owns a house together with their spouse as tenancy by the entirety, joint. They have a bank account that's joint. They have a retirement account that names their spouse as beneficiary, but they have a bank account that they've always kept separate, nobody else's name on it, just their own, and they never wanted anybody else to touch it. What's going to happen? Now, in that case, the home is going to go to the spouse, the joint bank account will go to the spouse, the retirement account will go to the named beneficiary, but for the other account that was held separately, that account is going to go according to what we call intestacy. So there'll be an administration proceeding in the court where the spouse can petition to become the administrator of the estate to gather that bank account and distribute it. After expenses of the estate, what happens when someone dies without a will is that the first $50,000 goes to the spouse, and the remainder will be divided amongst the spouse and the children, 50% to the spouse, 50% to the children. So what this means is, let's say that that bank account was $300,000. Now, the spouse may have already gotten the house, already gotten the joint bank account, already gotten the IRA, but then with this separate bank account, it's going to go the first $50,000 to the spouse, so that gets us down to $250,000, and then the next $125,000, half of the account, is going to go to the spouse. So in the end, this spouse got the house, the joint bank account, the retirement account, $175,000 of the account that was in the person's sole name, and then the other $125,000 of that account went to the children. So it's very important to realize that that's what's going to happen if you do nothing. More importantly, especially with assets that are going to that spouse, is that you have to realize that once they go to the spouse, then upon that spouse's subsequent death, those assets are going to go according to how that person's estate is going to go. And so when we talk about blended families, this is especially important, because if all the assets are just shifting to the spouse, who might be the second spouse and not the parent of the children, then upon the second death, all those assets may be going to that person's children, or if they don't have children, to their family members. And so that's why planning is even more important with these blended families as it is when you don't have the blended family. Another thing I want to discuss off the bat is the right of election. So people say all the time, you may have heard it, that in New York State, you can't disinherit your spouse. So what does that really mean? So you can say in your will everything goes to my children and I'm not giving anything to my spouse. But the spouse has what we call a right of election. So the spouse can always claim in court, in surrogate's court after death, that they have a right to 1/3 of the estate. What does that mean? So let's take a similar example to the first one I gave you. There's the home, the joint bank account, the bank account in the individual's name, and the retirement account. But in this example, let's say that the home and the joint bank account name the spouse, but that there's a will that leaves anything in the person's sole name to their children from a prior marriage, and the retirement accounts go to the children from a prior marriage. And I'm going to throw in a life insurance policy as well that has the children named as beneficiary of the life insurance policy. Now, in that case, the spouse has this 1/3 right of election. So what that means is that when you add up all of these assets, the spouse can get 1/3. But the spouse cannot get 1/3 with the life insurance included. So we add up the value of the home at date of death, the value of the joint bank account, the value of the individual bank account, the value of the retirement account, and that's what the spouse has a right to 1/3 of. The life insurance death benefit is outside of this, and the children will get that in full. So if the children have, or if the spouse has the right to 1/3 of what these assets are, then we say, well, she already got the house and she got the joint bank account. So she may not have gotten one bank account and the retirement account, but we have to actually look at the numbers. And if the house and the joint bank account equals more than 1/3 of the estate, then we have satisfied the 1/3 right of election, because that surviving spouse got more than their 1/3 absolute right. So it's very important to realize that when you're talking about what a spouse is entitled to, that's what it means, that you can't disinherit your spouse. They have this right. Now, when people do prenuptial agreements, they very often will waive the right of election. So what they're saying is, I promise not to seek 1/3 from your estate, you promise not to seek 1/3 from my estate, and we're going to have this contract that's going to determine how things are distributed. So that's why prenuptial agreements become very popular, especially in second marriages, because it often irons out these issues in advance, which is always a good thing to do to prepare. So when the first spouse dies, one of the questions we always have for clients is, what are your goals here? You know, we really need to sit, and now the question becomes, who is my client? So if a husband and a wife come in and they want to talk about their estate planning, and one or both of them has children from a prior marriage, and they have assets that they share and assets that are separate, and they may have assets that they have because they inherited them from a family member, and then assets that they've bought together, and assets that they had from their prior marriage. So it gets very jumbled, very complicated. In those cases, the first conversation we need to have with them is, who do we represent here? And if there are inherent differences of opinion between the two spouses as to how the estate should be handled, because part of this depends on who dies first, then we may not be able to represent both parties. Now, if both parties are in agreement that they can, even if they don't agree on every issue, as long as there's full transparency, and we find that we are able to give them both proper advice based on their goals, then we can move forward with representing them, and we can sign documents where they acknowledge that there may be this conflict, but they're okay, and they trust that they're both getting the accurate advice, and also are comfortable with the fact that they can't say anything to us as the attorneys for both spouses that the other spouse doesn't hear. There can't be any secrets here. We have to lay everything on the table and come up with the best option for both spouses and their intended beneficiaries. So I'm going to give two examples of the types of families we tend to see when we're dealing with blended families. So for example, we may have someone who it's two spouses, They've been together for 40 or 50 years. They have children from a prior marriage, but they're both very happy to take care of each other first and then split everything equally amongst their children from the prior marriage. They fully trust that whichever spouse survives is going to do the right thing and give the assets the way that they all decided. And the children have no infighting amongst them, and everybody's comfortable with a joint plan. Now, in that case, we may have everything go from one spouse to the other spouse, and both spouses' documents divide everything equally amongst the children, and they may want a very simple plan. But now let's add in that all of those facts are the same, but maybe they're a little bit uncomfortable with the idea that when one person dies, everything's in the other person's name, and they could maybe go change their will, and that might disinherit the children from the first to die spouse. That might be something that concerns them. Well, then maybe when the first spouse dies, the documents say that everything goes for the benefit of the second spouse, so they have it for their lifetime. And maybe we make two trustees of that trust for that spouse, and one is the one spouse's child and the other is the other spouse's child. So everybody's open book and everything's transparent. And then upon the death of the second spouse, again, all of the assets are distributed amongst the children equally. So that's the way we can kind of have a stopgap measure to make sure everybody's comfortable. That is the easier scenario. Everybody's on the same page. Everyone had children from a prior marriage. What could also get difficult is if one spouse had children from a prior marriage, but the other did not. And it could also add in that one spouse came into the marriage with a lot more in terms of assets than the other spouse. Or while they were married, one spouse earned a great deal of income and the other did not. And people have different feelings as to how things will be handled. So when we're talking to them, again, in every situation, we're asking, who are the beneficiaries? Do both spouses have common beneficiaries, or do they differ in who they want to leave assets to? And who do they feel comfortable empowering to be a trustee for a trust for the spouse that continues to live, or the executor of the estate to make sure that the wishes are followed properly? I'm going to give another example. Now, let's say you have one spouse who had a family property that they had inherited from their parents, and they brought it into their first marriage just like they brought it into their second marriage, and it's always been their own. And they want to make sure that that property passes along to their children only, because they want to keep it in their own bloodline, because that was always the intention of this family property. But as for the other assets, they are happy for their other assets, if they're the first to die, to be used for the benefit of their spouse, and then to pass on to maybe, again, back to their own children once they know their spouse is cared for. And the other spouse can do the same with their own assets and pass it to that spouse's children. Now, in that case, we have to look at, do we possibly create a trust for this family property? Perhaps we create a trust for this family property at the time that the individuals are still alive. So maybe that spouse who has that property puts the property in a trust, and it's clear that that trust continues on for her family. If she wants her spouse to be able to utilize that property if she's the first to die, well, then we can put that in as well. But if that's the case, then we need to start to talk about, well, then who's responsible for paying the expenses of the property? Who's going to pay the utilities? If the roof needs repair, who's going to pay for a roof repair? If they rent the property out, who will get the income from the trust? These are all relevant questions as to how this property is going to continue. And especially if you have a trust that only has this property in it because that's for the children, but everything else is for the benefit of the spouse, then you need to make sure that there are assets available to fund and pay for the upkeep of that property, which could vary year to year based on the amount. We've had situations where we've had to say, well, you know what, if the spouse is using the property 50% of the time and the children are using the property 50% of the time, maybe that's how we need to distribute the payment for utilities. And then again, determining if rent comes in. Maybe if they rent the property, the first thing that goes to pay the utilities is the rental income from the property. But all of this, again, is going to be different case by case, but it's going to be very important that this is discussed in advance to try and minimize any conflict about it after the fact. I think it's also really important to realize, what will the surviving spouse think about their deceased spouse's children being the trustee of a trust that they're the benefit of? So these are all, again, things that you just really need to talk through and figure out, how's everybody going to feel about the practicality of the situation. In the beginning, I spoke about the right of election, that 1/3 right that the spouse has. I think it's really important to note that, let's say upon my death, I state that all of my assets go into a trust for the benefit of my spouse. My child, who is not my spouse's child, is the trustee, manages it, makes determinations as to how much to distribute to my spouse, how much my spouse can use. And my spouse, upon my death, is very unhappy with this. They do not want to be beholden to my child. They don't want to have to ask for distributions. Well, in that instance, that surviving spouse can exercise that right of election. Now, that seems strange, right? They got 100% of the assets in a trust. It's all there for their benefit. It's there for the taking at the trustee's discretion. So by exercising the right of election, what my spouse is saying is, I don't want 100% of those assets in a trust. I'm happy if you just give me 1/3 outright, send me a check for 1/3 of what the total estate was. And if I get my 1/3 outright, you can take your trust. I don't want any part of it. And that's a right that a spouse always has if they're unhappy with that terms of the trust, if they just want to sever from the estate and those who were in charge of the estate. Some other provisions that we put into documents often when we have second marriages, or even with first marriages when we're concerned about second marriages upon the death of maybe one of the spouses, is that if you are to remarry, that you must have a prenuptial agreement, and what the terms of that prenuptial agreement will have to be, because some people are concerned that if something should happen to them and all the assets are there for their spouse and their spouse now gets a new spouse, they want to make sure that there are assets preserved for their children as opposed to it all being spent on the new spouse and possibly that new spouse's family. So you want to make sure that these terms are laid out properly. We also sometimes put in that there's a change in how assets are distributed to the surviving spouse if there is a remarriage. And again, this is all going to depend on the individual situation of spouses and their relationship with their beneficiaries and how they want things to be distributed. It's also very important when you have estate planning for two spouses in a second marriage situation or even in a first marriage situation, that it's clear if you want anything to go to the beneficiaries at the first death. So what I mean is, let's say that I want to make sure that all my nieces and nephews get a $5,000 gift from my estate. My documents should make clear, do I want my nieces and nephews to get $5,000 at my death if my spouse is still alive, or only will they get that money when both myself and my spouse are gone? And these are all the nuances of drafting documents that are very important to make sure that the intention is followed. We also have to make sure, just like in any other estate planning, as within blended families, are we taking into account the fact that the children may have divorces down the line? And do we want to make sure that the children have protection in case of divorce so that the inheritance that is left to them is not going to be taken in that circumstance. And so a lot of times upon the death of the individual or of both spouses, we have assets go into a trust for the benefit of the child. And the child may be able to be, I say child, but this could very easily be a 50-year-old person. When that person inherits, they can be their own trustee and they can manage the trust themselves. But based on the terms of the trust, we can build in creditor protection so that if they then have a divorce, that's not an issue. So I can't stress enough the importance of discussing all of the different things that could happen, especially once you get into a blended family situation and dealing with how assets are distributed. I often get the question, upon my death and my will, if my will has to be probated, who are determined to be my next of kin? And it is important to note that stepchildren, so children that are not your blood but are the children of your spouse, are not considered next of kin for those who die intestate without a will, or even just in probate for who gets notice of the will. So your stepchildren are not included unless, of course, you've legally adopted them, in which case they are included because adopted children are treated as though they were biological children. But stepchildren are not included in that case. It doesn't relate exactly, but also important to notice when we're talking about blended families is if I do not have any parents who are living and I'm unmarried and I have no children, my next of kin would be my siblings. And if I have two half siblings, we share one parent, and I have two full siblings, we share both of our parents, those four individuals are all treated equally for the purposes of my estate. So a half sibling has the same relation in this situation as a full sibling has. And that's something that's often asked by people because they want to make sure, who are we actually including when we're talking about who gets notice of probate when my will's probated, or if I die without a will, who automatically gets the shares of my estate because they're my next of kin. I think the other thing that's important to point out, and this comes up in a lot of our different discussions that we have, is does someone need a trust, or are they perfectly well suited to have a left will and testament only? This comes up with blended families because it often comes up in circumstances of who your beneficiaries are and who you might be disinheriting or giving notice of probate to. So I'll explain what I'm referring to. When somebody has this spouse who if somebody upon their death, their will has to be probated. Notice of probate has to go to their next of kin. If you have a spouse and children, that's who notice of probate goes to. As I said before, if you don't have a spouse and children and you have parents only, it will go to your parents. If not, then to your siblings. If your siblings are no longer living, it will go to their children, and then it continues out over the family tree. We always tell people that because notice of probate needs to be given to your next of kin, you want to make sure that this isn't going to create an issue, because when they get notice of probate, your next of kin basically gets something in the mail. If they're not willing to sign and have notarized a waiver saying, I don't want any part of this estate, I'm just gonna back off, then they get a citation in the mail, and that citation gives them a date and time that they can come to court and voice their objections if they have any. And so if we see that that might be an issue, we might be advising that that client should be avoiding probate at their death to avoid that issue. So I'll give an example that if I am disinheriting somebody or attempting to disinherit somebody who is my legal next of kin, then that person can come in and contest. And they can basically, whether they win or not, they can certainly create enough of a fuss that it's a drain of resources and time on the estate. And a lot of people want to avoid that. So if you have a blended family and you are leaving assets to your spouse, and then also to your spouse and your own children, or your spouse and your own children, but you're disinheriting one of your children, you're going to want to think about, do we need to avoid probate? And that's when we get into revocable trust, because if you make it so that while you're alive, your trust owns assets, then at death, there is nowhere for no probate of that will, because all the assets are owned by the trust. So I'll give an example of a client that I had recently. There were two individuals. They were married, and they weren't a blended family because neither had children from any previous relationship or marriage, but they did have different beneficiaries. So they didn't have children. So one individual had some family members, more remote family members, cousins, etc., that they wanted to benefit. And the other had a family member and charities that they wanted to distribute assets to. But importantly, they wanted to make sure that their spouse was cared for first. So again, we needed to know what their goals were to see what they wanted done. So what we discussed was that if there are two individuals and they each have a will that says everything goes to the other person, then basically the survivor of the two, all of the assets go according to that person's will. So for example, if the person who was leaving everything to these family members died first, their assets would, according to the wills they had when they first came in to see me, those assets would all go to the survivor of the spouses. And then once that person owned everything, all of those assets would go to the survivor's beneficiaries, which was the one family member of his and those charities. That wasn't their intention, and they didn't realize that. They thought that they were thinking that if we each have a will, we each say where we want things to go, that's how they're going to go. What we ended up being able to do was to put the assets into revocable trusts. And so basically at the top level, they each had a trust. They were each beneficiaries. Trustees of both trusts. So they had shared control of the trust because they had no issue trusting each other. Upon the first death, so let's say this person died first, the assets stayed in this trust, but they turned into a trust for the benefit of this individual. So this individual survived. They still had their own trust and the second level trust that was for the benefit of that beneficiary. And then upon the second death, these assets went to that person's beneficiaries, and these assets went to that person's beneficiaries. So in the end, they were both taken care of while they were alive, but we honored the fact that they had totally separate beneficiaries. And they didn't even realize that their original documents weren't accomplishing that goal. So back to what is most important to the two spouses and how in a legal structure can we best accommodate that, being tax efficient and being efficient with dollars spent on the administration of the estates after both the first and the second death. Okay, well, thank you everyone for joining us today. That's it for this topic. We hope you join us again. So we're all hoping that you stay home and safe, and we'll speak to you soon. Have a great day.